I knew I'd seen her before, right. No, this is actually I've known Bonner Bethel for years. I've known people who've taught. This is my first time on this campus, and looks quite appealing. But you've also, I guess the rule is have at least one Cernkovich here at all times. Is that it? But I've also had the benefit, you've given me two marvelous gifts of people who've been our aides, work closely with us. That's Margot Kalaki and now our own Abby Wilkinson. I was at a meeting in D.C. of the Horatio Alger Society giving awards to the people, and each one would get a video and then speak for 90 seconds, and one of them said, I told my wife, darling, in your wildest dreams, did you ever imagine I could be getting an award of this kind? And she said, darling, I don't know quite how to convey this to you, but you're not in my wildest dreams. Well, I hope I'm not in yours. I hope I'm not in. I may not be in yours, but it's an honor to be here today to make this pitch. And of course, Lawrence, he's heard me on this before. You could just leave now or stand up here and give the talk. But in this vein, I've argued for a long while that the comedians are really in the same business as the philosophers, that they make their livings off of playing on the shades of meaning in the language. You think of Groucho Marx. Leaving a party late at night, he stops to talk to the hostess and says, I've had a lovely evening. This wasn't it. For some people, the jokes reveal propositions that they take to be the anchoring principles of their lives. Think of Bertrand Russell's joke about Mrs. Christine Franklin Ladd, who professed to be a solipsist. She professed not to know that there was anyone in the world apart from herself, but she's so disappointed she couldn't find other solipsists to come to meetings of solipsists. Now, if our ears were properly tuned, we'd probably induce the same urbane giggling when you hear somebody come up with one of the most well-traveled fallacies in our public discourse. In fact, Bob Bork used this line in that debate we had, that if there were these moral truths that held in all places, they would be recognized in all places. But the very fact that they inspire such widespread disagreement must stand as prima facie evidence that they are not true. There are no propositions of that kind. Well, of course, as the philosopher would tell us, that argument reduces to this proposition. The very presence of disagreement in any matter of consequence indicates the absence of truth. Of course, I register my own disagreement with that proposition. And by its own terms, it reveals its falsity. It's what the philosophers would call a self-refuting proposition. And yet, on the basis of a proposition exactly of that kind, Harry Blackman was able to found a whole new branch of our jurisprudence. And in Blackman's hands, it sounded this way. When so many learned people in philosophy and religion have not been able to settle on the question of when human life begins, obviously there is no truth that the judges are in a position to declare. Again, it's simply the same proposition. It self-destructs in 7 seconds. It self-destructs because it runs into the canons of reason, the law of contradiction. And when you're dealing with the laws of reason that way, you're backing into the ground of what some of us take to be the ground of the natural law. Not theories. My late friend Dan Robinson, who's contributed important works to the neural sciences, did 18 books, ended up lecturing on Kant and Reid at Oxford. Dan said he wanted as the epitaph on his tombstone, he died without a theory. He died without a theory. And there was a president of Amherst College a while back who said, Hadley has a theory of natural law. And I said, when you say something of that kind, you rather suggest that you're standing back in wholesome detachment, watching theories whiz past, and somehow you're able to form judgments about the fragments of those theories that are plausible or implausible, true or false, take me back to the ground on which you're making those judgments about the things you reliably know, and you be led back to the ground that some of us take to be the very ground of the natural law. When Dan Robinson was making his comment about theories, he was really taking the line of Thomas Reid, the great Scott philosopher, talking about those matters of common sense that we are compelled to take for granted, the things we know before we start engaging in theories. So before we start bantering with David Hume about the meaning of causation, the ordinary man knows his own active powers to cause his own acts to happen. That's the sort of thing that we're dealing with. And what I want to suggest to you is that when we're looking for the ground of natural law, we are backing into those things so fundamental, so fundamental that they are the things we are compelled to take for granted. They are so fundamental that we may not be aware any longer that we're aware of them. So that they involve what my friend Jay Budashevsky calls those things we cannot not know. Those things we cannot not know. Well, I offer that as my prelude. And I want to take you back to that night in November 2008, when Barack Obama was elected President of the United States, and he was addressing a vast throng in my hometown, in Grant Park in Chicago. And the very next morning, I had an email from Jim Stoner at LSU saying, "Did you see last night? He said 221. I mean, for those who are aware of these things, it was a heresy. 220. We've built this country calloused hand by calloused hand for 221 years. Well, Mr. Obama professed to admire Lincoln, but he kept revealing that he wasn't aware of the deepest grounds of Lincoln's teaching. Lincoln said, 77 years ago, our fathers brought forth this nation. If we count back 87 years from Gettysburg in 1863, we end up in 1776. Obama took the meaning of the beginning of the country with 1787, the drafting of the Constitution. Lincoln understood that the beginning of the country came with the articulation of that proposition, as he called it, the father of all principle among us, that all men are created equal, the only rightful government over human beings must depend on the consent of the governed. He understood that the very purpose of a constitution was to convey into a stream of practical action a system consistent with those underlying principles. The first constitution did not work. It sort of abetted all the centrifugal tendencies in our lives. This is the second constitution we've been working on. So as Lincoln understood, the Union is older than the Constitution. The Constitution was made for a more perfect union. Lincoln caught it this way with drawing upon Proverbs, that a word fitly spoken is like an apple of gold in a frame of silver. That the frame was made for the apple, not the apple for the frame. The Constitution was made for the Union, for those first principles to define the character of the Union, not the Union for the Constitution. Okay. The founders understood a world of law and principles of law that were there before the Constitution. The Constitution was not the source of their understanding of the principles of law or the principles of judgment on matters of right and wrong. Lawyers like Alexander Hamilton, John Marshall, James Wilson showed a remarkable knack, as I'll show you, of tracing their judgments back to those anchoring axioms that would be there regardless of the Constitution, the principles that would be there even if there were no Constitution. And of that more in a moment. During the argument over Obamacare in 2012, my friend Greg Katsas did the first day on the Anti-Injunction Act. And in the course of that argument, he invoked that argument of John Marshall's in the old Dartmouth College case, that to impose upon people a contract they did not wish to have, as compelling them to buy medical insurance, to impose upon them a contract they did not wish could be as bad as violating, suspending the obligation of a contract they consciously and willingly made. And years later, Justice Story would say in his commentaries, that principle would be true even if there were no Constitution. Just as John Quincy Adams would later argue, that right to petition the government, as he's trying to petition the government over the matter of slavery, that right to petition the government is simply implicit in the very logic of a Republican government. It would be there even if it had not been mentioned in the First Amendment. It would be there even if there were no First Amendment. It would be there even if there were no Constitution. Alexander Hamilton gave us a quick lesson on this point in the Federalist 78 when he said, we work under this rule of construction that any later statute supersedes an earlier one. But that's not the rule we work with the Constitution, because the Constitution coming earlier must be able to override the statute coming later, or else it loses its function as a control on the legislative power. Then he asks, well, how do we know this? Because this rule is not set down anywhere in the positive law of the Constitution. It's critical to our functioning. How do we know it? And he said, it's simply the reason and nature of the thing. John Locke caught the logic of this matter in the three questions he posed when he said, what is the source of the law? The legislature that makes the law. Well, then what is the source of the legislature? A constitution that tells us whether we have a legislature, how many chambers, what kinds of powers it has. Then he said the third question, well, then what is the source of the Constitution? It must be, he said, something wholly antecedent to the positive law, the law that it simply posits or enacts statutes and edicts. It must be wholly antecedent to the positive law. It must involve the deeper natural right of a people to determine the terms of its own governance. Now, it's worth pointing out, and it's worth maybe at the outset, that the principles of natural law could be reconciled with a number of different constitutions, from different parliamentary system, one-house legislature. People ask me, well, do you really need the Constitution? Well, yes, of course. It's a matter of structure. I do need to know things like, may a state offer its territory, make its territory available as a base for a foreign power, as a naval or military base? Who succeeds to the president? Who does the army obey if a president dies in office? I've got to know things like that. Those are matters of the structure. And as my late friend Scalia used to point out, it was the structure that worked to preserve our freedom. Long before the Supreme Court began applying the First Amendment to the states, what was preserving that freedom of speech? Mainly the fact that people whose freedom was threatened would have access to the ballot in beating back those people in politics who'd be threatening their freedom, as much as the Alien Sedition laws were defeated politically in 1800, long before the Supreme Court ever intimated that they might be unconstitutional. Okay. I say it makes eminent sense, if you'd understand the Constitution, to consult those people who were able to give us the most luminous account of what they thought it meant and the underlying principles on which it was based. But it was precisely because they had this knack of tracing their judgments back to those anchoring axioms that they marked themselves as a rather exemplary, remarkable group, still deserving our close study. John Marshall, in a kind of throwaway line at the end of Gibbons versus Ogden on the Commerce Clause, John Marshall apologized to his readers for spending so much time demonstrating what should stand the class of an axiom. He assumed that all of his readers, his literate readers, knew that before you can carry out a demonstration or an experiment, certain axioms had to be in place, like the law of contradiction. You cannot be or not be at the same time. If there's A, angle A, and there's non-A, if somebody didn't understand that, it couldn't be explained to him in the form of the demonstration. It was one of those things that one had to understand before one walks into the demonstration. And that the founders were utterly clear on this point was nowhere expressed with more elegance or economy than in that introductory paragraph that Alexander Hamilton struck off for the Fellows 31, where the subject was taxation. And in the course of that paper, he reached no conclusion more astounding than anything that, say, Bob Dole or Chuck Grassley would reach in our own time. But any disinterested observer looking at the text would notice at once some strikingly different furnishings of mind. Because this is how Hamilton put it. He said, in disquisitions of every kind, there are certain primary truths, or first principles, upon which all subsequent reasonings must depend. These contain, he said, an internal evidence which, antecedent to all combination, command the assent of the mind. Of this nature, he said, are those maxims of geometry. The two lines cannot enclose a space. Two things equal to one another, to each other are equal to, two things equal to a third thing are equal to one another. And of like nature are those maxims of ethics and politics. You cannot have an effect without a cause, that the means must be proportioned to the end, and there ought to be no limitation placed on a power destined to effect a purpose which is itself incapable of limitation. Just the way Bob Dole would have said it, I used to think, if he just sort of put his mind to it. Okay. Now, when Hamilton referred to the things that could be grasped as first principles, he was referring to things so fundamental they could be readily grasped through the common sense of ordinary folk. Aquinas said that the divine law we know through revelation, but the natural law we know through that reasoning that is accessible to ordinary people, you might say natural to people. And my own teaching, my own experience as a teacher, there is no example of that kind of reasoning that is so instantly grasped and understood as that fragment that Lincoln wrote for himself, where he imagined himself engaged in a conversation with an owner of slaves, putting the question, why are you justified in making a slave of that black man? Is it because he's less intelligent than you? Ah, beware, the next white man who comes along, more intelligent than you, may rightly enslave you. It's because he's darker than you are. Ah, beware again, the next white man who comes along with a complexion lighter than yours may rightly enslave you. The pitch is, there's nothing you could cite to justify the enslavement of black people that would not apply to many white people as well. There is no appeal to faith or revelation here. This is an argument that could be understood across the religious divisions. And some of us in the pro-life movement simply drew on the same model of principled reasoning. Why is that offspring in the womb anything less than human? Doesn't speak yet? Well, neither do deaf mutes. Doesn't have arms or legs? Well, other people lose arms or legs in the course of their lives without losing anything necessary to their standing as human beings to receive the protections of the law. Once again, there's no appeal to revelation. It's simply a principled argument composed of embryology, a principal reason. In other words, you don't have to be Catholic to understand this argument, but that has been precisely the teaching of the Church. This is not a matter of faith, but of that reasoning of the natural law. Jefferson caught this when he said in the letter that state a moral case to a plowman or a professor. The plowman is as apt to get it right because he's not been led astray by artificial rules. Lawyers these days may not be as apt to see things through the common sense moral reasoning of the natural law because they've been diverted with theories. But if we look more closely, I think we'll find there's not the slightest disagreement about those precepts of the natural law. And they're so woven, as I say, into our practical judgments that we may hardly even be aware that we're using them. What kinds of things critical to our law do ordinary people understand it that way? Of course, Ordinary people readily understand the anchoring axiom of the law of contradiction. They know they cannot be and not be at the same time. Even people without advanced degrees can spot where people are telling them inconsistent stories. And we find that ordinary people grasp that anchoring proposition that Lincoln called it, and it comes as soon as we put the questions, ask ordinary people, what do you think ordinary people would say if we gave them this problem? How is it that even in this age of animal rights, we're still not signing labor contracts with our horses and cows? Why aren't we seeking the informed consent of our household pets before we authorize surgery on them? My surmise that ordinary people would wonder what the hell this is about, right? And what is it that they do? They would grasp their own way that there was only one kind of creature who could understand what it means to make a promise, make a contract, be held responsible, understand that he's committed to honoring this obligation he undertook, even when it no longer accords with his inclinations or interests. And the understanding was, we cannot rule people of that kind in the way we are compelled to rule horses and cows. That's just another way of backing into all men are created equal. No man is by nature the ruler of other men in the way that men must be rulers of dogs and horses. The ordinary man would understand that. But apart from that point, let me move to two axioms that thread through our practical judgments at every level. And the first one involves that axiom that Thomas Reed and James Wilson regard as the first principle of our moral judgment. And I put it to you again in the form of the question put to the proverbial man on the street. And I ask you, what do you think he'd say? What do you guess he'd say if he learned that Jones, accused of a serious crime, I modestly put this to you, if he learns that Jones, accused of a serious crime, was in intensive care, recovering from the surgery at the time the crime was committed, or that Jones was heavily medicated at the time and had no firm control of himself. He's accused of a serious crime. What do you think the average man would say then? I'm open. Does anyone doubt that ordinary people, undistracted by theories, would quickly say, of course, Jones could not have been guilty of the crime. He should not be tried or convicted. That is to say, they would back into the proposition that Thomas Reed, Kant, understood to be the first principle of practical judgments, which could be stated this way. It makes no sense to cast moral judgments of praise and blame on people if they don't have the active powers to cause their own acts to happen. And so we say we don't hold people blameworthy for acts they were powerless to effect. If Jones wasn't born at the time the crime was committed, we take that as powerful evidence for his innocence. Now, this proposition can be involved in the insanity defense. It could be involved in one of the grounds for the wrongness of racial discrimination, holding people responsible for something it's not simply caused by their race. We can have many arguments. This is where some part of my friend Scalia didn't understand. You could have many arguments over the question, was Jones really not in control for himself? Was he really in the ICU? Was he really under hypnosis? We could have many arguments about that point. The whole thing may be contingent, still requires our imagination and the taking of evidence. But the one thing that is never contingent, the one thing that will never be open to doubt, is the principle itself. That if Jones was not in control of his acts, he cannot be held blameworthy or responsible. Thomas Reed said that proposition, anchoring proposition of our practical judgment, that is as true and as necessary as any axiom in Euclid. Well, how many propositions of this kind do you have? Well, more than people seem to realize. From that central proposition, you could start drawing out implications. So John Stuart Mill would say, we stop using the language of like and dislike and begin using the language of right and wrong, as we think people may rightly be punished for what they're doing. But then the corollary of that is that we are justified in punishing only wrongdoers, and if we respect the difference between innocence and guilt, that obliges us to use the most demanding methods of testing evidence with the canons of rational judgment, instead of having people run over hot coals or outrun a mob in the street. And as you just can draw it out that speed further, you come out with this kind of proposition, that anyone accused of a crime should have access to the witnesses and evidence against him for the sake of being able to rebut them, and in rebutting them, producing a verdict that is substantively accurate in distinguishing between innocence and guilt as the predicate of punishment. Well, if that's the case, as I'm drawing it out, what I'm saying is the very logic of a moral judgment gives us access to that proposition. And anyone accused of a crime should have the right to confront the witnesses against him. That right would be there even if it had not been made explicit in the Sixth Amendment. By the very logic of the thing and the rule of law, it would be there even if there were no Constitution. Okay? And of course, it's worth adding this point, that of course we recognize that judges may be corrupted and juries may be corrupted. We could be working under these rules and people could be making grave mistakes and serious injustices may be coming through the system, and yet nothing in that record would dislodge us from the conviction that anything calling itself the rule of law must have an arrangement in which people accused of crimes know the charges brought against them. They must have access to the evidence and reasoning in order to rebut them. But once we're saying that, we're saying these truths are necessary and, pardon the expression, categorical. They'll keep their truth even when we find ourselves besieged by all kinds of imperfect performances in the judges and juries about it. What I've been describing here so far, before I get to that second one, is a kind of discipline of judgment as simple as it's tight. And the late Judge George Sutherland used to draw out his judgments in this way. And when judges work in this way, they readily saw that nothing in this chain of moral reasoning can possibly tell judges the right price for a pair of pants, the right number of divisions in breaking up AT&T, the standards that govern wage price controls. And this was the kind of elementary reasoning that Justice Sutherland drew upon when he, in a famous case in 1923, struck down the law on minimum wages for women in the District of Columbia. He had been a leader in the cause of votes for women, a Western Republican. He saw this thing as patronizing. He was going to the rescue of Willie Lyons, running an elevator at the Congress Hotel in Washington. She was getting $33 a month, 2 meals a day. She loved the job. She wanted to keep it. Her employers would have loved to keep her there, but under the new laws, they couldn't keep a woman in that job for less than $71 a month. But the law that cast its protections over women cast no such protections over men, and men were still free to take the job at the market rate, which turned out to be, guess what, $33 a month and 2 meals a day. So this law passed out of tenderness toward women was having the effect of systematically replacing women in jobs with men. I gave a talk at the Supreme Court of Historical Society. Ruth Ginsburg was there, and she says, now the feminists agree that George Sutherland had it right in that case. But what he was doing was not drawing on theories of economics, but doing things that are just deeply jural. He's saying, from the fact that someone is a woman, we can't make any moral projections of what kind of income that woman needed to preserve her morality, as though rich people were more moral than poor people. He said, the relation between earnings and morals is not capable of standardization. It can't be shown that well-paid women safeguard their morals more carefully than those who are poorly paid. It's kind of a determinism based on gender, and a comparable determinism based on class. To assume that any person who's called an employer is capable of paying any stipulated wage. It may be someone is simply trying to get supplemental income, not needing income to support a family. It's just the kind of job needed to give somebody a little experience in working. We can't simply assume that just by knowing that somebody is an employer, we know how much he's capable of paying for any kind of a job, and so on. But what he's drawing on was the same kind of proposition. I want you to mull over with me, take a second, that the court was mulling over in a case called Edwards versus California, when the state of California tried to block indigents coming into the state during the time of Depression. And the court, and Justice Burns would say, poverty and immorality are not synonymous. From the fact that someone is poor, we cannot assume his presence would have a deteriorating or degrading effect on the state. And Justice Jackson would say something comparable, that California had no right to make the condition of Duncan's purse, his poverty, a ground for drawing adverse moral inferences about him. All these people from different angles were backing into, I'm telling you, one of the propositions so fundamental that it just pervades so many of our cases without people recognizing it. Let me crystallize it for you and see how you'd explain it, and help you explain it. Once again, put this to the proverbial man on the street. Help me with this. What do you think the proverbial man on the street would say if we put this question in? From the fact that someone is tall or short, heavy or thin, that he's darker or lighter, that he stutters, that he is deaf, can you make any inferences as to whether you're dealing with a good or a bad man who deserved to be welcomed or shunned? What's your reading of this? My reading is that the man on the street would say, no, he couldn't make that kind of judgment. Why not? Help me. What's getting in the way? What is he thinking? What's the truth that lies behind this? Yeah, Mr.
Gennaro.
Yeah.
Well, none of those characteristics that were mentioned have anything to do with the will, which is where good and evil is decided in a person. If that's where a person can become good, is through choices that they make, and none of those are choices.
Ah, okay. So could you put it this way, that when we say we have a list of things that we say are morally insignificant, this is helpful. That what you see is we can't impute to any of them a deterministic force determining the moral conduct of any, apart from the will of that person, his own moral judgments about what he's going to do. You're saying that you just can't impute a deterministic force to these things. The most dramatic example I can give you is one where I was at the court at the time. The famous Baby Doe case in Long Island in the 80s, where the child was born with spina bifida and Down syndrome. And the Reagan administration went to court because the parents with the doctors withheld life-sustaining treatment from the child. And the Reagan administration went to court to find out what was the ground on which you withheld that treatment. If you tell us that the condition was inoperable, we're not going to compel you to put people through a surgery and engage in futile surgery. But if you're telling us that a child afflicted with spina bifida or Down syndrome has a life not worth living, that's not a medical judgment, is it? Why not?
Because that's, well, first of all, it's not in the realm of medical decisions. That's judging a life's worth is, it's not a medical thing.
It's not a medical. See, Ralph Judge Winter in the court below said, if this turned out to be, you're turning away from the child because the child is black, he said, that's not a medical judgment. You're telling us that anybody born black has less of a life or life less worth living. this is the key vice here, the key problem. That's through so many of these cases. We're drawing a moral inference on the basis of attributes of this kind that cannot possibly justify a moral inference, that we can draw inference about the rightness, the goodness of the life that these people may lead. Now, the question is, if we simply now shift the terrain, and instead of the case coming from Long Island, it comes from Tehran or Nairobi, would the judgment be different? No. Why not?
Because location is also somebody else.
No, I think you had the touch. You don't think it's going to make a difference. You think east or west, it would be as wrong to draw this moral inference about somebody's illness and draw a moral implication from his illness, from his height, his weight, no matter what. So what we're saying is, this judgment does not spring from some ethic of this tribe of Americans. It's not distinctly American. It's simply grounded in what Thomas Mead would call the mint of our nature, the way we are constituted, and the fact that we can never draw any moral inferences on the basis of attributes of these kinds that are wholly wanting in the kind of deterministic force to control the moral outcomes. Which case, I used to say to my friend Scalia, if that's the case, you're backing into the natural law. This is the natural law. You're telling us the ground of a moral judgment that will ground in the laws of reason, that will hold true in all places, universal in its reach, and in contradistinction to the argument he used to make, say there is nothing the least foggy about these things. As we see them bearing on these cases, they are very precise, concrete, knowable. Right? My late friend Scalia, in one of his last cases, a case out of Florida, declared that the first axiom of the First Amendment is this: as a general rule, the state has no power to ban speech on the basis of its content. Now, quite apart from the fact that I've been arguing the contrary position for 40 years, how does it stand as an axiom? That axiom is contained nowhere in my text of the First Amendment. So what's going on? I think Scalia simply thinks that behind this judgment is something, a construction he regards as sensible, or as Alexander Hamilton would say, it's one of those constructions which, antecedent to all experience or combination, commands the assent of the mind, which is to say, it's like a first principle, a necessary truth. He's backing again into the N word. He's doing natural law without quite being aware he was doing it. So I used to say, to ask whether judges can actually get through their day without touching these axioms of reason, the very ground of the natural law, is like asking, can I order the coffee without using syntax? They're doing it all the time. They're persistently appealing to those axioms of reason that have to stand behind their judgment. And as that, with that character Molière, they don't realize they've been speaking prose all their lives. And that sense of principles at work, left unseen, takes me back to a moment that provides my concluding point. And the bells are charming, just to ring the importance of the point. About a dozen years ago, I was doing a talk on natural law at the law school at Fordham. And at dinner, the dean remarked there was very little discussion of natural law in the early days of the Republic by people like John Marshall, Alexander Hamilton, and by the judges. To which my friend Dan Robertson remarked, yeah, there was very little discussion of the alphabet either at the time. It just happened to be woven into everything they do. And it finally struck me that we have here was a species of what the philosophers would call a category mistake. And to apply like Gilbert Ryle's example to myself, let's say someone visited me at Amherst I showed him the beautiful room where I taught for so many years. I'd show him the playing fields on a Saturday in the fall. Take him to the social center, to the earth sciences building, administration building. I take him back to the house to give him a drink, and he says, "That's all very lovely, but I thought you were going to show me the college." I thought that's what I've been doing. And then I realized it would come out this way. The dean says to me, "Look, all you've shown me is how a bunch of very literate lawyers kept tracing their judgments back to the axioms that were there before the Constitution and to the axioms and rights that would be there even if there were no Constitution. When are you going to show me how they did natural law?" We just did. They did it. They did it without affectation. If you permit me to end by quoting from myself, something truly gauche. When we launched this project in the natural law about 8 years ago, I offered this plea to our friends doing conservative jurisprudence. I asked, why should we settle in with a mode of reasoning about the law that gives us a kind of sing-song morality with terms such as activism, which have no moral content? And some people think that the effort to address those moral questions at the heart of the law is just too ambitious, too risky, too difficult to do well, and likely to license mischief. Our friends sought to seek safety in contriving formulas of the positive law, while cautioning us again not to ask those questions that run beneath the surface to the core of things. But in that path, I argued, there has been no safety, and therefore no prudence, and beyond that, no coherence. Because we can't give our best reasons, our fullest reasons, the reasons that give the most coherent account of the decisions we make and the law that we're shaping. And the question at the end is, well, why should you? Why should we settle in with something so diminished when set against the serious moral questions that remain before us? Why wouldn't we rather strengthen a conservative jurisprudence by drawing again on the understanding of that first generation on natural right, a teaching that will always be with us, always there to be read and to be learned anew? And where could we find a better assurance that the law we're preserving will be as comprehensible and compelling, as resonant with common sense in the next generation as in our own, and as it may ever be? Okay, thanks for taking